Hey guys, so you're ready for it? So my screen capture program is not working. It made me update it. It's not recognizing the mic. It's opening and closing. So I uninstalled it. I'll figure out something else. So for now, we're going to do the video this way. So I'm going to talk about specifically, because I have a different interpretation, honestly, of the 14th Amendment, that Trump is somewhat quote-unquote overturning, or whatever, the language of it, saying his executive order is basically, if you come here, you're an illegal, and you pop out a kid, your fucking kid is not a U.S. citizen. So I've got some paperwork here I printed real quick that I'll read too. But before we do that, this is my little pocket constitution book. It's neat. 14th Amendment, Section 1 is what it's talking about. It's literally one sentence. Very beginning, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Okay? So that is the 14th Amendment. Here's the deal. This 22 attorney generals have since filed, a lawsuit. This will go to the Supreme Court, 100%. I think this is excellent because it needs to be interpreted one way or the other. And I believe this will be interpreted on Trump's behalf. And here's why. Because and I could be wrong, but when SCOTUS looks at laws, okay, precedents, any type of history background behind things, they've since ditched some other stuff, Chevron and stuff recently, but beside the point. They look at the history of the law that they're looking at, of why it was enacted to begin with, to see if whatever is in front of them even fits into the category which the law sits. So, with that being said, the 14th Amendment of the United States was ratified in 1868, granting citizenship to all persons born and naturalized in the United States, including formerly enslaved people, and granted all citizens equal protections of the law. It says, one of the three amendments passed during the Construction era to abolish slavery and to establish civil and legal rights for Black Americans. It became the basis for landmark Supreme Court decisions over the years, like Brown versus Board of Education, stuff like that. But it says here, that sentence that I read, this clearly repudiates the Supreme Court's notorious 1857 Dred Scott decision, in which the Chief Justice Roger Taney wrote that black men, even if born free, could not claim rights of citizenship under the federal Constitution. So the 14th Amendment basically said every slave that was freed under Lincoln's situation became a citizen of the United States. Okay? Period. End of story. This had to do with slavery and blacks. It says, in the late April, Representative Thaddeus Stevens introduced a plan that combined several different pieces of legislation proposals: civil rights for black people, how to apportion representatives in Congress, which are the other sections of this situation, punitive measures against former Confederate States of America, and repudiation of the federal war debt, into a single constitutional amendment. After the House and Senate both voted to make this amendment on June 1866, it was submitted to the states for ratification. President Johnson made it clear his opposition of the 14th Amendment as it made its way through the ratification process, but congressional elections in late 1866 gave Republicans veto-proof majorities in both House and Senate. So, in other words, the Republicans passed this. Southern states also resisted, but Congress required them to ratify the 13th and 14th Amendment as a condition of regaining representation in Congress, and ongoing presence of Union Army in the former Confederate states ensured their compliance. On July 9th, 1868, Louisiana, South Carolina voted to ratify the 14th Amendment, making up to necessary 3/4 majority. So keep in mind, the Republicans are the ones who actually passed the 14th Amendment. But the point is, the history of the 14th Amendment had to do with slavery. Something needed to change. The 13th and 14th Amendment, something needed to change when Lincoln did his proclamation to put into law. They tried it through legislation, which I did not read, and it did not work out well because it wasn't written a specific way people liked, and then there was obviously Democrats who didn't like things. And again, like I said, in 1866, there was elections that gave Republicans veto proof in both houses. So that changed regardless. They probably could have passed the legislation at that point, but the ratification was already going on. So the point is, if the Supreme Court looks at this in its historical context of how the Constitution was written, why the Constitution was written a certain way, and does not interpret it as a living and breathing document to update it over the ages, which if they interpret it as a living and breathing document, it will include illegal immigrants popping their kids out, or just immigrants, period, popping their kids out. But he's specifically targeting the birthright citizenship situation where illegals are doing this. But the point is, my argument to this is that it's not a living and breathing document. Never have thought that at all. The historical context had specifically to do with enslaved blacks that became free, that they were denied by a Supreme Court in 1857 under the Dred Scott decision that they were allowed to claim rights of citizenship. So this amendment overturned that decision. So this has a historical context of specifically dealing with civil rights and slavery. I don't see this not going Trump's way, literally, if they look at the historical context and it's an original document interpretation of the Constitution, not a living and breathing document. There are anyone who's on a visa that pops a kid out, it's the same thing, birthright citizenship. Anyone who's here illegally, anyone who's just here on, work permit, all that type of shit. Anyone who brings their fucking pregnant bitch over here and pops out a kid, they become a U.S. citizen. And I do not believe that is what Congress originally did, period, which they didn't, originally did back in 1866 when they first put this to the states to get ratified. I don't think this will go against Trump. I think these attorney generals don't have a choice. They have to bring this to SCOTUS because they just want to or whatever. And it's politically driven, obviously. But the point is, it's almost going to be one of those things where either they let Trump do it or they bring it to SCOTUS for interpretation. So there's no way this wasn't going to get challenged. And it needs to be challenged because we need a real definition of what's going on here. Does it apply to illegals, visas, work permits, random people coming in this country? Or doesn't it? And that's the question. And I think it doesn't because of the historical context. This is Are You Ready For It? Take care, guys. Have a great day.